Thank you very much indeed for your cooperation in the presentation of this case digitally or virtually, as one says. Mr. Guthrie, would you like to give your opinions?
For the appellant, I do have with me Ms. Naina Patel, who is here, but your lordships will be relieved to know she's at a safe social distance in the room.
Good. Thank you very much, Mr. Guthrie.
That is correct, my lords, and appearing with me is Mrs. Nadine White-Leng, who is also socially distanced.
Thank you very much indeed. Now, I don't want to start on the saga, but I see that the statement of facts and issues was not wholly agreed. I've had occasion in the past to say that the statement of facts and issues is not an occasion for a further forensic joust. If facts cannot be agreed, then they should not appear in the statement of facts and issues. The place for tendentious claims, or contentious, perhaps I should say, is, of course, the printed case of the parties, not the statement of facts and issues. However, having said that, we won't refer to it further. Mr. Guthrie.
Well, my lords, I know that the board will have taken the opportunity to look at the underlying documents. I'll give an indication, if I may, of how we intend to proceed. Yes. Our focus is on the issues relating to waiver. Your lordships will have seen from the last part of our written case, in paragraphs 70 to 77, there is consideration of the issues relating to damages awarded for shortfalls in delivery of fuel on certain specified occasions. My lords, in due course, we intend to take that quite shortly. Paragraphs 78 to 80 also refer to an argument that the liquid damages provisions of the agreement between the parties amounted to a penalty. We don't intend to argue the penalty point. As I say, the main focus of the appeal is on the findings made by the judge and endorsed by the Court of Appeal on the issues relating to waiver. My lords, I can also tell you that there is no issue, certainly no substantial issue, as to the legal principles involved. It's their application to the facts of this case that is in question. As a preliminary matter, my lords, we would want to make a general point as to the approach taken by the Court of Appeal. We submit that the Court of Appeal was wrong to treat the issues as primarily issues of fact. This is not a case in our submission where the approach in cases such as Watt and Thomas should readily be applied. That case is in the bundle of authorities, but I know that I needn't take your lordships to it. The principles it recognizes is so well known, but an appellate court, of course, should be slow to reverse findings of fact, particularly where the judge at first instance saw and heard the witnesses. However, in the present case, the witness's testimony was very much secondary to the legal issues. In due course, there is one area at which I will ask you to look at the judge's reference to the witness's oral evidence. But overall, the issues depended upon a correct analysis of the agreement and the events, in particular the correspondence that took place after the closure of the Provenza storage facility in St. Croix. I would respectfully submit that the Court of Appeal was, and indeed the board is, in as good a position to decide these as was the judge. Can I have a moment? My screen has gone a little funny. I need to. No, it's gone back again. That's. I'm sorry. That's all right. My lord, it is a notable matter of fact that in the judgment of the Court of Appeal, there is very little reference to the correspondence between the parties. and no reference to the details of that correspondence at all, although the details of the correspondence and its effect were important and indeed were fundamental to the judge's decision. And we say that the effect of what was contained in the correspondence was not a plain matter of fact, but a matter of law or a matter of mixed fact and law. And we say also by way of a general introduction that it follows from what I've said that the board's time-honored practice of not interfering with concurrent findings of fact should not apply to the appeal. I see Lord Legate has a...
Yes, Lord Legate.
Are there not two distinct questions? One is whether the principle of election applies to the right under the contract in this case. Yeah. The second question, however, is if this is a case in which there was an election that arose, whether your clients made that election. That's a question of fact, isn't it, on which we can't go behind the judge's finding if that question arises.
Well, it does depend upon the analysis of what took place as a matter of fact. And as I've said, your lordships are in as good a position as the judge to decide that by reference to the correspondence. And indeed,
yes, we may be in as good a position to decide it, but should we not be reticent about reaching a conclusion which is in opposition to that of the judge, who, as you have said, has had the advantage of hearing the witnesses?
Well, my submissions will be aimed at dispelling any reticence that your lordships may feel about that. But if I can say this, obviously the point at which one must start is the relevant contractual terms. And by way of introduction, your lordships will have picked up that this was not the first agreement between the parties, who had a long history of doing business, and that it's common ground between us that there had been lengthy discussions between the parties, and also common ground that when they came to negotiate this particular agreement, dated the 30th of August 2014, they were aware that the appellant source of supply in St. Croix, Hovensa, might be closed. And as a result, they included the specific provisions in the agreement that your lordships will find in the electronic bundle at page 889. Your lordships, just so I'm quite clear, I hope there's no difficulty in the enumeration of the bundles between my own and yours, because this has happened in the past. I'm looking at the numbers at the bottom of the page in the middle, and this is EB0889, where you'll see clause 10 of the agreement between the parties. My Lord Briggs has his hand up.
Well, I'm afraid, Mr. Guthrie, at that point in the bundle, we're about 13 pages apart. In other words, 876 at the bottom right-hand corner is 88 electronic, and 889 paper, which is I think what you're using, must be actually 902 electronic.
Well, I think in fairness to Mr. Guthrie, you did say electronic bundle 889.
Yes.
Yeah.
Well, that is the number at the foot in the center.
No.
889, yes. That's clause 10.
Really? I'm so sorry. Yes, it's entirely my fault. I'm afraid, thinking of the last hearing, looking at the one in the bottom right-hand corner. But no, you're right. EB889 is good.
Well, that's a relief to me. My lords, I don't know whether it would really be of assistance to read it out, because I know that your lordships.
No, I don't think you need to do that. We've read it several times already.
But perhaps I could just place particular emphasis on the provisions in 10.2 on page 890. which show that in the event of the interference or the availability from Havensa, if that is delayed, hindered, interfered with, curtailed, or prevented, then the seller shall be at liberty, the seller being Delta, to withhold, reduce, or suspend the deliveries hereunder to such extent as the seller may in its absolute discretion think fit, and the seller shall not be bound to purchase or otherwise make good shortages from such causes. And then a request must be made in writing and specify the reason for the request with supporting documents, etc. Also in subclause 3, in addition to the foregoing, in all requests for performance relief, the non-performing party must prove that the party took reasonable steps to minimize delay or damages caused by foreseeable events, that the party substantially fulfilled non-excused obligations, and that the other party was timely notified of the likelihood or actual occurrence of an offence described in clause 10. My Lords, having looked at clause 10, the appellant makes the following observations. The clause does not contain any time limit for a request for performance relief in the event of the closure of the facilities at Havensa. Nor does it contain any bar on the exercise of such a right beyond satisfaction of the terms of clause 10.1d and clause 10.2 to 3. It doesn't impose any time limit on the duration of any performance relief granted, or the number of times performance relief could be requested or granted. In summary, clause 10 provided Delta with the basis for any type of one-off, temporary, and indefinite performance relief. And it was only in that last case that it would amount to an effective contractual termination of the agreement. We also ask the board to note the obligation in clause 10.3, which I've just read, on the non-performing party to take all reasonable steps to minimize delay or damages in relation to a foreseeable event. And the classic foreseeable event in this particular case was the closure of the facilities at Havensa, which, as you will have seen, had been in the contemplation of the parties when the contract was made. We say that 10.3 recognized a duty to try and preserve the agreement prior to exercising a right to indefinite performance relief to determine the contract. The point being, the significant point, is that the clause did not require Delta to make an immediate decision whether to affirm or terminate the agreement. And we submit that it is that aspect of the contract which has so far been misunderstood. Now, my Lords, it was misunderstood, first of all, in our submission by BVIEC, although it's not quite clear that they misunderstood it in that way to begin with. Obviously, what the parties thought the contract meant is not in any sense decisive, but we can see from the evidence that BVIEC, certainly by the time the proceedings have been commenced, saw clause 10 in, I think the phrase is binary terms, as providing Delta with a choice either to proceed with the agreement or not. And this was confirmed in evidence by Mr. Abraham, who is the principal representative of BVIEC. And we can see that the reference to his evidence is page 300 79, using the numbers again, obviously at the bottom of the page in the middle. At that point, my lords, he is being cross-examined by Mr. Neal for Delta. And at the bottom of the page, you'll see that Mr. Neal says, my question to you is that this clause was inserted. This must have been a reason why it was inserted. And all I'm asking you for is, you said it was not because there would be adverse consequences to Delta. So I'm saying to you then, what was the reason you inserted that into the contract? And the answer is, it was inserted in the contract, in my view, to provide an exit out of the contract for the defendant, Delta. Now, well, his view of the contract is, as I say, by no means a reliable guide to what it actually meant. But the fact is, it is something to take into account when one looks at the correspondence in due course. When the matter came before the judge at first instance, there are a number of occasions where it was clear that Mrs. Justice Beyer, thought that the agreement required the appellant either to bring the agreement to an end there and then on the closure of Havensa, or not to do so. My lords, if I can take you to the passages of the judgment where that is clearest, it's page 320, if I may. It begins at paragraph 56. And she clearly adopts the same view as Mr. Abraham. She says, upon close inspection of 10.2, it is indeed recognized that the parties had in fact contracted an out for the defendants, among other things, upon the interruption of the supply of products from their St. Croix facility, also known as Havensa. In fact, it was Mr. Abraham who, in answer to persistent cross-examination, and then she refers to the passage in his evidence that I've just taken you to.
You've just taken us to, yes.
And at 58, thus it is clear to this court that even from the negotiating stage of the contract, parties recognized that not only would the closure of Havensa be a reality in the future, but further, that such closure would have given the defendants the right to terminate the contract and withhold, reduce, or suspend the deliveries to such extent as the seller may, in its absolute discretion, think fit. In December 2004, on the first, in fact, Havensa indicated... 2014. Sorry. On the first, in fact, Havensa indicated to the defendants their intention to close down their facilities. There was no indication from the witnesses for the defendants in either evidence or in chief or in their extensive cross-examination when this was in fact communicated to them, although admittedly the letter itself was dated the 1st of December. In this court's mind, this is a telling omission on the part of the defendants in failing to lead this evidence, which would have been essential to the reliance they sought to place on this fact. I note in passing, it's not quite clear why she said that. She then, if you go on to paragraph 62, you see her saying, this casual notification was further compounded by letter of the 28th of January 2015, who then belatedly sent the actual letter of notice of closure and sought a meeting to discuss our current contract and the implications relating to the closure of Havensa. Then she says, this evidence thereby lends itself clearly to the unmistakable conclusion that based on the Havensa closure and the further notification of the same, that at that point at the very latest, the defendant's right arose to seek permanent performance relief on the part of the defendant, relying on clause 10.2 of the contract. So it's quite clear that the judge saw the contract and that clause of the contract in terms as really requiring on the closure of Havensa the defendant to make up its mind whether to affirm the agreement or not. But in our respectful submission, that is not what clause 10 of the contract actually meant, and it was a mistake. It was also the approach which was taken by...
I'm sorry, just to go back to the paragraph. The judge says that the defendant's right arose to seek permanent performance relief. Yeah. I mean, there's nothing wrong with that, is there?
There's nothing wrong with that, but she says, and I'll come back to it at a later stage, that the basis of her decision is that they were obliged to choose one way or the other when that right arose. But that is...
Well, it may be that the later part of the judgment makes that clear, but certainly yes. At paragraph 63, she's saying that, is she?
Yes. Well, I think, Lord, at the... if we go to 69, I can show you this.
Yes.
She says, so what is clear to this court is by the end of February 2015, the decision. And I think paragraph 64 makes it clear. This did, the right arose, and then she says at 64, this did not, however, and the defendants in January 2015 did not seek to invoke their right to termination. What instead appears to have happened is that the defendants sought to explore an alternative avenue. We would say that consistently with the contract, there was nothing wrong with them doing that. But it wasn't an alternative in the sense that they had to do one or the other. It was open to them to enter into negotiations with the respondent, and that is exactly what they did. And the same approach to the contract is shown by the Court of Appeal's approach. If I can take your lordships to two passages in the Court of Appeal judgment. The first is at paragraph 12, which is about page, I think it's 701. In paragraph 12, she refers, sorry, not she, Mr. Justice Mitchell, the respondent defended the judge's factual finding on the basis that if there was a clear choice available to the appellant after the closure of the events of the facility, either to continue to supply the agreed products to the respondent using an alternative facility or to terminate the contract, that the appellant elected to continue to supply the respondent using an alternative storage facility, and that the appellant's decision to continue to do so was clearly communicated to the respondent by the appellant's words and actions. In paragraph 13, there is a quotation or a reference to the judgment of Lord Gough in, I think it's the Kanchenjunga case, which we don't need to look at because the principles are accepted. She says, waiver by election arises when a state of affairs comes into existence in which one party to a contract becomes entitled, either under the terms of the contract or by general law, to exercise a right, and that party has to decide whether or not to do so. The party making the election has to choose between two alternative and inconsistent courses of action or remedies. Once he has made his election to pursue one course, he's bound by it and cannot thereafter pursue the alternative course. And then I don't think I need continue with that, because the principle which Lord Gough is explaining is that the election, the party is confronted with the need to elect when it's confronted with two alternative and inconsistent courses of action. And we say that under the contract in the present case, Delta wasn't confronted or required to make a choice between two alternative and inconsistent courses of action at all. the matter becomes even clearer in the Court of Appeal. At paragraph 24, at this point, my lords, the court is considering the no waiver clause, which I'll need to come on to perhaps a little later. But if I ask you to read, it's page 705, the court says this: the waiver in issue in this case is one arising from a conscious business decision made by a corporation engaged in business across states, territories, and nationalities to take a certain course of action in what it considers to be its commercial interest. That is, to continue to supply products to a major statutory corporation with which it had contracted, notwithstanding a circumstance which entitled it to terminate the contract and relieve itself of its obligation to supply the agreed products to the statutory corporation at the agreed place. And then the next sentence: in so doing, it jettisoned the alternative course of action of terminating the contract when the opportunity to do so presented itself. Those are strong words, but what the Court of Appeal is saying, in agreement with the judge, is that because the Delta acted in the way it did and did not immediately terminate the contract on the closure of Havensa, it jettisoned the alternative course of action of terminating the contract. And indeed, effectively, it abandoned its rights under Clause 10. And we say that that is wrong. What happened was that the appellant reasonably attempted to locate an alternative supplier, which would enable it to continue to supply the respondent. In the event, it was unsuccessful, although it was able to purchase fuel from Shell Antilles in Antigua. But at the same time, it entered into negotiations with the respondent. This did not mean that it had elected to abandon its rights under Clause 10 or jettison that course of action. Clause 10, among other things, required it to take all steps necessary to minimize loss to the respondent. Lords, that is what I submit is the correct interpretation of the contractual term. It's necessary then to go to the facts in a little detail, including the correspondence between the parties, to see its effect. And my lord, in doing that, I ask your lordships also to focus on the second fundamental issue relating to the issue of waiver, which is whether there was a clear and unequivocal representation made by the appellant that it had jettisoned or abandoned its right to terminate the agreement in reliance on Clause 10. And I think there's no dispute between us as to the law on that. It is necessary for the doctrine to apply to show a clear and unequivocal representation, as I've mentioned. And my lords, the relevant run of correspondence begins in the electronic bundle at page 936.
Before you move on to that, do you take this point too, that Clause 10 does not confer a right to terminate the contract, which means an act which brings both parties' obligations to an end? It simply gives one party a right to withhold performance, which may amount in practice to a similar state of affairs, but it isn't conceptually the same thing.
Well, Lords, it's been treated, I think, in the courts below as being exactly the same thing. Whether conceptually that's quite correct, but it did give the right to withhold performance of the contract in the absolute discretion of both parties. And I think it's been, the language of termination has in fact been used throughout this case.
I'm just querying whether that's actually correct.
Well, my lord, I'm not sure what my reaction should be to that query, whether, but perhaps if necessary, I can revisit it. My lords, I was going to work. My Lord Hamlin has a.
Yeah, just on that point, Guthrie. If you choose to suspend deliveries indefinitely, contract continues, if circumstances change, why can't you resume deliveries? That's the first question. Second question is, according to the judge and the Court of Appeal, when did the election occur?
Yeah. Well, the judge appears to have thought it occurred almost at once, certainly before the correspondence I'm going to take you to, which in our respectful submission, that was unreasonable. I think your lordship's first.
You don't have to go further. You don't have to go further than say that it was unreasonable. You really have to say that it was an unsustainable situation, don't you?
Yes. Well, in that case, my word should have been unsustainable. But I would respectfully submit that on the language of the contract and in the events which happened, it was unsustainable. I mean, the judge laid great store. It's not, in fact, clear why she did so, on the fact that the formal notification of the Venza closure was not made until January the 28th. But this was not a complaint which was made by anybody at the time. I mean, BVIECs didn't respond saying, well, why haven't you told us this before? And in fact, in reality, I mean, the Virgin Islands being a fairly small place, one can infer that this wasn't a surprise to them at all. Bearing in mind that it had been on the cards, and indeed, at one stage, there appeared to be an agreement for BVI at least to use its best endeavors to make submissions to the United States, to the Senate, in relation to the closure of the report. But we say it was an unsustainable conclusion that the Delta were obliged to invoke clause 10.2 to the effect of withholding indefinite performance relief when the Hovensa closure took place. Whether it had the right to do so or not, it was not obliged to do so under the contract terms. And we can see in a moment what, in fact, it did do. Well, the first letter, as I say, is at 936, dated January the 28th. And you'll see that it's dated the 28th of January. It says, you'll note that our current contract stipulates storage in Hovensa. With this being in the case, we would like to schedule a meeting with you to discuss our current contract and the implications thereof relating to the closing of Hovensa. I await your urgent response to this matter. Now, not only was there no response, as I've mentioned, to the effect that why are you only telling us this now? There was, in fact, no response to this letter at all. There's no reply from BVIEC to what is a plain indication that there needs to be some agreement or some discussion as to what contractual effects of the closure are. There's then correspondence to between the parties, which the judge laid some store on, but which we say was she was really rather partial about and tended to cherry pick certain parts of it. The first letters at 936, 937, I'm sorry, relates to the parts of clause 10 which dealt with deliveries and shortfalls of deliveries of fuel. And the letter to Mr. Abraham from Mr. Sylvester says, I write to invoke performance relief with regards to the understorage of 10-day supply, equating to 300,000 gallons of inventory in the British Virgin Islands. You'll recall that there was a previous letter, and I didn't take you to this because it's just about shortfalls in delivery, dated January the 27th, We're now in the transition phase to Antigua for the lifting of product. Documentation will be sent to you in usual manner in accordance to contract. This under inventory is caused for this very reason, as we are now loading in Antigua today to be back in the BVI market on Tuesday. This performance relief, therefore, is in relation to the closing of the Venza and the transition to a new loading part in Antigua. The judge regarded that as a clear and unequivocal representation that the Delta, right? The Delta had elected to, if you like, abandon its rights under the agreement. In other words, by this time there was the election, if you like, had been both made and communicated, and we say that that is an unsustainable conclusion. At the most, it is the indication of an intention to move to Antigua. What it is not is a clear and unequivocal election to abandon the contractual right to terminate the agreement. And particularly this is the case, and this is something the judge didn't mention, in the circumstances of the unanswered letter dated the 28th of January, in other words, some 4 or 5 days before. The intention of the letter dated the 28th was plainly to commence a series of negotiations. And that is indeed what might have been expected to take place. One letter about a storage facility in the interim, which is not clear and unequivocal in relation to the contractual rights at all, cannot possibly be satisfactory to support a conclusion that by this time Delta had elected to waive their rights under the contract. At this point, there's a meeting in the history on February the 6th, and I'll come back to that if I may. But going on through the correspondence, there is a further letter which deals with storage facilities on page 938 and also with 939. Now, again, the judge thought that the letter at page 939 was important because it referred to the fact that our new port has one berth. This impacts on the timing of and scheduling. Now, that, in our respectful submission, cannot possibly bear the weight she put on it. Again, the negotiations between the parties have not been commenced even, or whether they've been commenced because there's been a meeting on the 6th of February. But this reference on page 939, again, can't be seen as a clear and unequivocal representation that Delta has abandoned any rights. Then, as we come to, well, I can ask you, if I may, to ignore pages 941 and 942 because the same letter has got into the bundle twice, and go to the letter at page 943, which is dated February the 19th. This is an important letter from the appellant's point of view, my lords. You'll see that it's addressed to Mr. Abraham again. It has a subject, negotiating additional costs regarding loading in Antigua. But it then continues, we write regarding our contract, as you are aware from our written correspondence on January, I'm not quite sure who made the alteration to the date there. Perhaps it doesn't matter, but some of the underlining, etc., obviously came into being with the litigation. Avenza's storage terminal on St. Croix has been closed due to disputes between the owners and the USVI government. You are also aware that Delta based its supply operations around this terminal and was always concerned about its ability to fulfill contractual commitments if this closure became a reality. Therefore, the contract clearly provides that if Hovensa goes out of business, we can seek redress for termination or renegotiation of the contract as highlighted in the requisite clauses. That is a direct reference to the termination possibility. This letter was quoted by the judge, but not this part of it. Then the next sentence, Delta Petroleum has sought to secure loading and supply in Antigua. In the process of making the switch to our new loading point, we have incurred additional charges. These higher costs are real and make the contract unprofitable for us to continue to supply unless relief is achieved. We would be most grateful if the BVI Electricity Corporation could accommodate this increase in the contract premium relative to the Platts index, which is a method of calculating, I understand. In our initial conversation regarding this matter, including Mr. Abraham, Mr. Potter, Thomas Esposito, and Mr. Sylvester, the latter two are Delta people, you stated that BVIEC would prefer to see a minimal change in premium as the overall market has allowed you to reduce the fuel surcharge for us customers, which you don't want to offset at this time. You stated that BVIEC would be willing to review other mechanisms under the contract that would allow Delta to mitigate its higher costs. Then over the page, there are a number of proposals which are made as part of the negotiations. If I can go to the conclusion of the letter, kindly revert to us within 7 business days concerning A, your interest in negotiations, B, the date that you are available for further discussions on the matter. Based on our current losses, we believe something needs to change before the end of March, or we should prepare for the alternatives. And one asks, what does that mean? Well, that means, in the light of the fact that at the beginning of the letter, the right to terminate has been referred to, the preservation by Delta of its rights under the contract. And certainly the judge, who thought effectively that the only relevant part of the letter was the sentences, has sought to secure loading and supply in Antigua in the process of making the switch to our new loading port, where we have incurred in additional charges. She thought that the expression in the process of making the switch to our new loading port was in effect equivalent to a clear and unequivocal representation that alternative arrangements had been made, and Delta was abandoning its right to terminate. And we say that that was an unsustainable approach to that letter. It was simply wrong. The letter which follows from BVIEC is at 945 to 946. And it is a response to that letter, but it doesn't take the issues with which we're concerned any further, save perhaps to say that it doesn't contradict the reference to termination of the contract in the letter before. And it doesn't, it doesn't say termination is no longer on the table. It doesn't refer to the alternatives which are referred to at the end of the letter. So it doesn't appear to disagree with the proposition that if something doesn't happen, then the alternatives have got to be looked at. From Delta's letter, those alternatives include the indefinite withholding of fuel. On the other hand, the next letter from Delta is at page 947. And that does deal with the matter in the first sentence. We are surprised that the tone of your last letter does not recognize our contractual right to renegotiate, terminate our supply agreement based on the loss of St. Croix as our regional supply hub. We want to continue supplying BVIEC as it remains our longest and most important relationship in the BVI, and look forward to finding to some mutually acceptable solution. Now, that cannot be construed, that letter, as a clear and unequivocal indication that Delta has abandoned its right to terminate the agreement under clause 10 of the agreement. The next letters, my lord, refer to one of...
Sorry, Mr. Guthrie, just on that, on my reading of the judge's judgment, the die had been cast by this point. As best I understood the judge's judgment, she relied essentially on the 3 letters in February to which you've taken us, the 2nd, the 13th and the 19th. And that seemed to be the foundation for her finding at paragraph 69 that by the end of February, the election had taken place. So I'm not sure that you get very much assistance from showing us a letter of the 9th of March.
Well, my lord, it's safe to say that it was plainly not clear to the parties that that die had been cast. Sorry, Lord Leggett.
Lord Leggett, yes.
Do you not have to draw a distinction, which I'm not sure you're making, between 2 different kinds of representation? And if the judge was right that this was an election that had to be made when the closure became known, and that either your clients had to terminate the contract or carry on with it, it's very hard to say that she wasn't entitled to find that they indicated clearly they intended to carry on with it. If, on the other hand, the question is, did they make a clear representation that they did not propose to rely on their contractual rights under the under clause 10, that is another matter. But as I read her judgment, she made no finding that they did make any such representation. Well, there's no alternative argument of waiver by estoppel if the BVIC don't succeed on the election point.
No, we have identified that as being in our written case, my lord, waiver by estoppel. If your lordships were of the view that what we said indicated that we were prepared to suspend the contract for the time being until something was sorted out, then that would amount to a waiver by estoppel.
You don't have to make up arguments that aren't advanced against you. The judge didn't find a waiver by estoppel.
No, that's true.
I mean,
if there was a distinction, to be made, I mean, I think the distinction would be that if it was a waiver by estoppel, then there would have to be some detriment demonstrated by BVIEC, but they continued to be supplied throughout.
But you don't have to argue here, do you, against the finding that the judge didn't make?
No, I don't. No. But by order,
let's not be distracted by that then.
But if we lost our rights, returning, I think, to my Lord Sale's question, surely, in order for us to have, in the Court of Appeal's words, abandoned or jettisoned our rights under the agreement, and for a estoppel by for a waiver by election to apply, then the clear and unequivocal representation must have been to that effect. And that is what we say never happened, because it was quite clear from the run of the correspondence that although we were trying to accommodate the respondent, and although we were trying to set up an alternative port in Antigua, that was always subject to the contract, which gave us a right of termination in the event that we could not do so, and that right was in our absolute discretion. So we respectfully submit that not only was the judge wrong in considering that under the contract we were obliged to make an immediate election, she was also wrong in suggesting that the references in the correspondence to a new port or transition to a new port were an unequivocal representation which would support that point. Well, if I can just go back, we were at page 949. And I think I mentioned that the letters from 949 on are all written in the context of one-off performance relief for delivery, for shortfalls in delivery. But if we go to page 964, I could just interpolate. There was a meeting between these dates on April the 16th. But on April the 21st, what we find is an internal memorandum created within BVIC by the respondent. I mean, it seems not to be a memorandum of a meeting as such, or minutes of a meeting. It's a brief to the chairman and members of BVIC's board of a meeting which was on the 21st of April. And that refers to the negotiations with Delta. They say that Delta is now contending that due to closure, their contract is no longer profitable, etc., and they need to be reimbursed, which is a summary of their position. It concludes with a reference to legal advice being sought. That's on page 965. As soon as the same is received, it will be circulated to members. And one can see with respect at this point that the relationship between the parties appears to change because the next relevant letter is dated the 30th of April. And I'm sorry, my lords, it has got out of order in the electronic bundle. But it may not be, I'll give you the reference to it. It's page 1139, but it may not be necessary to look at it because, again, it's one of the letters which refers to a one-off request for relief relating to storage levels. But at page 986 in the run of correspondence, there is a letter from BVIEC. I hope it's perhaps slightly more legible than your lordship's electronic bundle than it is in mine. But that letter is dated the 14th of May. And your lordships may care to note that it is a reply to the letter which I took you to from Delta, dated March the 9th, which is the letter 947.
This letter is very difficult to read, Mr. Guthrie, I'm afraid.
Yes, I'm sorry about that, my lords. I'm afraid.
Just so that you're aware that it's not.
Well, Lord, can I just, I think the first line reads, please refer to your letter of March the 9th, 2015. And that was the letter which I took you to, which began with the word, that was the letter which began with the words, we're surprised that the tone of your last letter does not recognize our contractual right to negotiate, terminate our supply agreement based on the loss of the St. Croix facilities. I have a better copy of the letter, which Ms. Patel's managed to get. Can I read it? It's very short.
Yes.
Please refer to your letter of March the 9th, 2015. You are correct to acknowledge our continued non-recognition of any right that you claim that Delta has to vary the terms of the fuel supply contract. It is clear from the correspondence that we have exchanged since the closure of the Havenza facilities that Delta has put in place an alternative arrangement for delivering fuel to the corporation in accordance with the contract. We look forward to your continued performance of the contract. Subject to the reservation set out in our letter of March the 4th, we stand ready to continue negotiations on the other matters raised in your letter, not related to the price of the fuel. My Lords, it is notable that that letter, which was written in reply to, if you like, what we would describe as Delta's reservation of its position in relation to termination of the contract, was not written for 2 months or over 2 months later. It is this letter which evidences, if you like, a change of heart on behalf of BVIEC. It's the first time in which it is suggested that there has been a change, the establishment of an alternative port, and it may well be a reasonable inference that this was an afterthought which came in respect of the legal advice that we know they were shortly about to receive. But the evidence of both Delta's witnesses, my lord, they both gave evidence, Mr. Silvestre and Mr. Esposito, was that this letter took them completely by surprise. They had not anticipated some allegation that they had altered their position in this way. And their reply is at page 987. And it immediately begins, the assumption we have put in place satisfactory alternative supply logistics subject to the Havensa closure is not true. As evidenced during the conversations and documentation, etc., the Antigua hub cost structure is significantly higher than existed in St. Croix. The only reason we continued to supply BVIEC this year is because you agreed that negotiations would take place to enloy our increased cost to be passed on in price or other value as an alternative to an outright termination of the agreement, as provided for by that agreement. Then they say BVIEC dragged discussions on, never presenting the argument proffered in your letter last week that we forfeited our rights to alter the contract by acting in good faith to continue supplying BVIEC under the existing agreement terms. Continued BVIEC supply from Antigua was always linked to a minimum contract price adjustment plus other possible incentives. In the last meeting before you presented the case to your board, we agreed that any price adjustments, well, I think I can leave that bit out. And then over the page, please make your intentions clear by May the 28th regarding the requested price adjustment. If the response is as indicated as your letter of last week, for the sake of secure supply for the BVI, are willing to load the next delivery and sell at a premium of whatever, while we continue to work with BVIEC to find a reasonable solution. During any extended period, either party could force a termination. And my lord, we would say that was a perfectly reasonable and proper letter to write, which reflects the reality of the situation. There had been no election, for some reason, the judge and the Court of Appeals seemed to think that Delta were acting in some way improperly by trying to get an increase in the price of the fuel that they were supplying. But that, with respect, was entirely unfair. An objective view of what was taking place was an attempt. I'm sorry, Lord Briggs, was that?
I was just dealing with a local disturbance which has gone away.
Well, pleased to hear that. But I saw you, your hand was in the air. Yeah.
Not at you, Mr. Guthrie.
Well, I think I probably made the point that I was anxious to make. There are further letters in which the parties repeat their position, and I'm not sure that it's necessary for your.
I just wonder how helpful this is. I mean, it's the interpretation is they're both setting out their stall us to resolve the issue, is it?
Well, my lord, it is, because the basis upon which the judge decided the matter was that there had been a clear and unequivocal representation that the appellant had abandoned its right to terminate the contract. And the Court of Appeal agreed with her, although it didn't.
I can understand that, but going through correspondence in which rival
I must take you up, Mr. Guth. You keep saying an unequivocal representation to abandon the contract. That would be relevant to the estoppel argument, which was not the basis on which the judge decided it. It's not relevant to the election question. You don't need to abandon your right to terminate. You just have to indicate which of two choices, possible choices you're making, by your contract or otherwise.
Sorry, my lord, I'm having a little difficulty with your microphone or my reception.
Well, I was just trying to say that you keep saying the judge found an unequivocal representation to abandon the contract. I don't think she did, but that would only have been relevant to an estoppel. The waiver by election, you don't have to abandon your right to terminate the contract. You simply have to exercise your choice one way or another. And if you carry on with the contract, then you're making the choice to do that, whether you've said you're abandoning your right to terminate or not. So it all depends on what the nature of the right was.
Well, my lord, surely you do, it's putting it another way, but you have to indicate your choice to carry on with the contract. The contract included the right to terminate. So the indication it's a circular argument with respect, because if we indicate our choice to continue with the contract pending negotiation, we're not abandoning our rights under the contract to withhold to indefinite performance relief. That's our.
Well, there are cases about whether you can spin out the choice for a bit if you have an election to terminate or affirm. But it's hard to spin it out for a few months. And anyway, the judge's findings, as been pointed out by Lord Sales, were that it was made, as it had to be, almost immediately.
But Lord, surely the question, the way in which one would put it is that the right to terminate being abandoned is relevant to waiver by election, because it is only choosing an alternative course of action that is inconsistent, which means that you're abandoning it. And we did not choose an alternative course of action which was inconsistent with the right to terminate the contract. And indeed, the distinction between the insistence on alternative and inconsistent courses of action is what is derived directly from the speech of Lord Gough, on which the Court of Appeal found that the judge was correct. And indeed, it was the basis of her judgment that we had chosen an alternative and inconsistent right, an inconsistent course of action. But we submit we plainly didn't. The reason that I take it to the correspondence, it demonstrates that so far from the judge who did rely on it, she cherry-picked, if you like, our use of the word new and our use of the word transition, and ignored the fact that we had repeatedly referred to our right to terminate the contract. So the basis of her and the Court of Appeal's decision against us did include a clear and unequivocal representation on our part. And we respectfully say that on an objective view of the correspondence, there was a finding that was unsustainable. I think I was only, because in answer to what my Lord Kerr's point is, it was only after the letter of the 14th of May from BVIEC to Delta that one can properly see this correspondence as each side setting out its stall before the 14th of May, when the change of heart took place on the part of EVIEC, the parties, the correspondence was not setting out its stall. It was an attempt to, on Delta's part, to negotiate its position and at the same time preserve its rights under the contract. And that is, they were not, so to speak, adopting opposite points of view until a later stage. My Lords, as I've said, the judge's analysis of the correspondence set great store on the language used in some of the letters, new loading port, etc. And she refers to this in particular on page 321. Which I think, my Lords, she refers in particular on that page to the letter of the 2nd of February. Paragraph 67, she refers particularly to the letter of the 13th of February. And at 65 and 66, she goes back, or going back in her judgment, she refers in particular to the letter of the, sorry, I've got a rogue reference in my note, I'm sorry. It's at paragraph 69, I think. What is clear to this court is by the end of February, on no less than 3 occasions, the defendants categorically referred to Antigua as being their new loading port. And then she goes on, this was in the court's mind, the start of the laying of the foundation by the defendant. They were seeking other considerations to set off higher costs. She criticized them for not spelling out in terms that the Antigua, the use of Antigua was not interim. Then I'm sorry, I think put a wrong reference in my note. If you just bear with me for one moment. Yes, in paragraph 68, she says, the defendant's regional general manager, a man who by his sheer position must have known what was going on, says to the chairman, says to the claimants, Delta Petroleum has sought to secure loading and supply in Antigua. My Lord, I took you to that letter, and you have my submissions that it doesn't mean anything like what the judge thought that it meant. And I repeat, it was on the basis of that correspondence that she decided the case against us. Well, my Lord, I'll move on to my next point. But there was one issue which, in our respectful submission, the judge did not satisfactorily resolve. The appellant's case was always that the respondent knew that the arrangement in Antigua was temporary. Mr. Sylvester and Mr. Esposito were adamant that they had referred to it as such in a meeting on the 6th of February 2015 and again on the 15th of April. And they gave evidence about this. Mr. Abraham disagreed. Mr. Porter, who was the respondent's chairman, I think, was also present at the meeting on the 6th of February, but he did not give evidence. Now, in our submission, that the evidence about this was not dealt with satisfactorily by the judge, in that she did not make any specific finding about it. Mr. Sylvester and Mr. Esposito were adamant, as I say, they had made the position clear. But it is the case that in his first and second affidavits, Mr. Abraham had not mentioned the meeting at all, although it's fair to say that he had not been told. He said he hadn't been told that Antigua was temporary. Well, the same can be said of the evidence about the meeting on the 16th of April. The judge, in her decision, only referred to the issue at one point, which is paragraph 11 on page 311. She said about that meeting only that the claimant and defendant had commenced discussions on February the 6th. During the discussions, the defendant requested an increase in the contract price. Since, it was asserted, there was an increase in the cost of supplying out of Antigua. However, the claimant, that's the electricity company, maintained that it advised the defendant from the inception of the discussions that its preference would be to maintain the existing contract price, etc. The nearest the judge got to a finding on the credibility of the witnesses, or she didn't decide this issue, but the nearest she got to any sort of finding about them is at paragraph 83, which is on page 326. And at that point, she said, further, upon this court making its own independent assessment of the correspondence that passed between the parties, whether it was for performance relief or otherwise, and despite the belated and unsubstantiated effort of the defendant's witnesses to seek to introduce oral communications in which it is alleged the position of the defendants were always to keep their options open, this court finds that the defendant's favor squarely falls within the parameters of waiver by election. She criticized them in relation to one matter at page 325. She said that, if put it in context, at the top of page, paragraph 80, despite counsel for the defendant's valiant effort to elicit admission from Mr. Abraham that the acts of the defendant were ambiguous, this court is of the view he was largely unsuccessful. Mr. Abraham, witness for the claimant, clearly stated that the understanding of the parties may have been different, but not the actions of the defendant. Under rigorous cross-examination, the claimant's general manager maintained that the correspondence between the parties was clear that they had chosen to continue supplying product from Antigua. This is further substantiated by the defendant's own witnesses, who this court found were less than forthright with this court, and at some points unquestionably evasive, and who eventually grudgingly admitted to counsel for the claimants on cross-examination that it was a business decision not to terminate the contract, knowing they were fully entitled to terminate. And then she reads, I won't read the questions and answers out, but just the conclusion. This is my question, Mr. Sylvester. You did not wish to terminate the contract. It's a simple yes or no. And he answered no. And then by the president, Mr. Esposito, you decided you would try and get an increase in the price or other concession. We agreed we would try and negotiate outside this contract to try and not terminate. Now, it seems to be in the judge's view that the the judge, the appellant wished to continue with the contract should somehow be held against them. But they were entitled to take the view they did. And in our respectful submission, the criticism of the judge makes of their oral evidence just isn't borne out. First of all, the view that they were unable to elicit an admission from Mr. Abraham that the acts were unambiguous simply flies in the face of the evidence which is shown on the transcript at 466 to 467. At the very bottom of 466, Mr. Neal, who's representing Delta, says, "Okay, Mr. Abraham, let's go again. You said it doesn't state it's permanent. It doesn't state that it's temporary." This is obviously a reference to the Antigua report. Doesn't it make it an ambiguous situation? For whom? The BVI electricity? No, for both sides, because if you're thinking one thing and we're thinking another thing, that would make it ambiguous. Well, it's ambiguous if both parties think something different. So it would seem that there was, in fact, a clear admission that there was ambiguity in the situation, at least. And the remainder of the judge's findings, although I can take you back to 81 to 83. Um, 83 in particular. She said, as I've already read, on this court making its own independent assessment of the correspondence that passed between the parties, for permanent relief or otherwise, despite the belated and unsubstantiated effort of witnesses to seek to introduce oral communications in which it is alleged that the position of the defendants was always to keep their options open. She refers there to belated and unsubstantiated, but there was clear evidence to that effect. And the finding that it was belated, it was simply unfair. If one looks at page 125 of the bundle, one finds that from this is Mr. Sylvester's first affidavit, one finds he spells out exactly what he says took place, and that there were clear discussions to the effect that their position was being kept open and that the Antigua facility was only temporary. So the judge, in our respectful submission, can be seen to have found against the witnesses, either on matters which were not really relevant to the conclusion, or simply wrongly, because it was the other way around. Lords, I think, my lords, I probably said what I want to say on the question of election by waiver. We respectfully submit that that is not apparent, that the decision that the Delta made a clear election, which was then communicated to the electricity company, is simply unsustainable by reference to the correspondence and the evidence. Well, can I briefly then, I think...
Lord Briggs.
I'm sorry.
No, sorry, I thought you had a hand up. All right, do continue, Mr. Guthrie. Yes, my lord.
I briefly mentioned clause 17, which was the no waiver clause. That is actually at page 893. I don't know if your lordships have looked at it yet. We have included an extract from Chitty and Fundle, which briefly says that such clauses are commonplace. But it reads, any neglect, forbearance, or indulgence on the part of either party relating to its strict rights under the agreement shall in no way be deemed a waiver, implied or otherwise, of such rights. If we are correct in our principal submissions that the facts don't indicate an election by waiver, then of course we don't have to worry about the clause which says not. But I would repeat that the rejection of this clause was based on the fact that the judge and the Court of Appeal considered that it would not apply in circumstances where there was a conscious business decision to abandon or jettison the rights under the agreement. And that is what, that was the basis of finding that the clause did not apply. Now, I've already, I think, covered the clause.
Yes, Mr. Guthrie, the judge found that there was a waiver in fact. I mean, if that is a correct finding, at the moment, I can't see that clause 17 helps you, because that's just concerned with saying that other things shall not be deemed to constitute a waiver. But if you've got a waiver in fact, in a relevant sense, clause 17 doesn't say that that won't take effect according to law in the usual way, does it?
No, my lord, it doesn't. I think the point we really make is that the basis upon which clause 17 was rejected by the court can't be sustained, because there's no conscious decision by the which would, so to speak, take it out of operation. If I just remind you, your lordships, what the Court of Appeal said about that. I think it was at paragraph 24 of the judgment. We do say that this really is at the heart of the errors which we respectfully submit the courts below made, because they say a conscious decision made by the corporation to continue to supply the products, notwithstanding circumstances.
Mr. Guthrie, what's the page for that?
I'm so sorry, it's 705. As the Court of Appeal puts it in this way, in continuing to supply the contract, the goods under the contract, we're talking about the period of January, February, March, well, while the negotiations were going on effectively. In deciding to do that, in so doing, Delta jettisoned the alternative course of action of terminating the contract when the opportunity to do so presented itself. And we say that decision is unsustainable. But it did form the basis of the rejection of the waiver clause. But if I'm right in my earlier submissions in relation to the issues of waiver, we don't need the clause 17, because.
But surely the findings in paragraph 24 don't bear on possible invocation of clause 17 at all, do they?
Well, I think the authorities suggest that if it was a correct conclusion that there was a conscious business decision, then that would take the matter out of the area of which could be restricted, which could be avoided by the use of a clause such as clause 17. I think the case it's in the bundle. It's the telephone case or post office case. I can take your lordships to it if necessary. But,
unless you feel it's necessary, I don't think that I certainly, for my part, don't require to look at it. Yes.
well, it is referred to in our written case, my lords.
Yes. Thank you very much.
Yes. And I think, well, maybe that's the simplest way of referring to it. Just have a moment. Well, if I may, I'll come back to it. I think what I was going to proceed to refer to was the question of damages, having really dealt with the question of waiver. The claim for damages is based on clause 3.7 of the agreement, which is at page 8, 7, and 9. Just prefacing that, your lordships would have realised that the Court of Appeal in any event made some deductions from the award of damages made by the judge. And at 8.7.9, I think I've got that, yes. Clause 7 at the foot there refers to the way in which damages, the liability for damages would arise and the way in which they would be calculated. And on page 8.0, there is a list of amounts, and subparagraph 8, subsection 8, the buyer shall forbear its claim to liquidated damages so long as the number of times the storage level falls below the stipulated storage fuel levels don't exceed 3 occasions in any calendar year. In the event that your lordships were with us on the waiver issues, then it follows that the appellant was entitled to rely on clause 10 to claim performance relief in respect of fuel shortages up until the termination of the agreement. So it also follows that the entire period for which liquidated damages were awarded, that is March to June 2015, fell within a period within which the appellant was entitled under the contract to withhold, reduce, or suspend deliveries without liability pursuant to clause 10 as a result of the Hovensa closure. And there had been, as your lordships have seen, I think, and they're referred to in our case, multiple requests for performance relief, which were referable to all those failures. So that if we are right on our waiver point, no award of liquidated damages should have been made for any of that period at all. There is a point which I should recognize, that there are two periods. There may be a problem for Delta in relation to the 3 grace periods, insofar as there was an absence of documentary support. But at a minimum, there are at least 2 periods of fuel shortages in respect of which requests for performance relief were made based on the Hovensa failure, which the High Court held to be invalid, which were not deducted by the Court of Appeal. Those, if I can just give you the references, my lord.
Mr. Guthrie, just before you do, you say the 3 grace periods. Can you just give us what dates you're referring to for those?
Yes, I think so. You just give me a moment.
Well, would this be a convenient time? We're going to take a 5-minute break. Would this be a convenient time, Mr. Guthrie?
Yes, certainly.
Yeah.
Certainly.
We'll resume in 5 minutes' time then. Thank you. Yes, Mr. Guthrie.
Lord, just to answer the questions raised by my Lord a moment ago. The 3 grace periods are identified in paragraph 77 of our written case, which is on page 1100. They are 19th of March, 14th of April, and 11th of May.
Yes.
And we set out the position in relation to the 2 other periods I mentioned in paragraph 76 of the written case, which is on page 1099. And we say that if you're with us on waiver, then those requests were the subject of valid requests for performance relief based on the Havensa closure. My Lord, just mentioning the Havensa closure, I think I should perhaps have been able to answer my Lord Hamlin's query a little earlier, much more clearly, because I think our Lord said that if it was indefinite withholding of deliveries, would there be any reason under the contract, if circumstances changed, to resurrect the position? I think I understood that question correctly, but that, of course, didn't apply because the clause was triggered by the Havensa closure. Once it was closed, it was closed. So there would be no question of resurrecting deliveries in the circumstances of this case. Well, just on that question, yes, also.
I wonder about that. I mean, I appreciate that the Havensa closure and diversion to Antigua increased costs and so on, which made it unattractive for the appellants to continue the supply. But suppose cost fell generally in the market, so that it then became attractive for the appellant to supply under the agreement. Given that the power in clause 10.1 includes a power to suspend, and what happens, I think it's 10.2, is in the absolute discretion of the party invoking the suspension, would it not have been available to the appellant in that sort of situation to reactivate the contract and say, well, we're ready to continue supplying now? It doesn't have to be from Havensa, but using an alternative supply, and we'd like to continue doing that, please.
Well, it's difficult to see how that would operate in practice, but I'm not sure how it applies really to the circumstances of our case, where what the judge found was an election to terminate the contract altogether, and we would emphasize the basis upon which she found that, and the Court of Appeal found that she was right, which was that we were faced with an election between 2 alternative and inconsistent courses of action. Now, we weren't. And it is that error which we say is at the heart of this case, and that once it is recognized, then the actions of the respondent in refusing to accept our application for performance relief amounted to a breach of the agreement, and indeed it would have entitled us to a counterclaim for damages.
I appreciate that. I thought you were answering Lord Hamlin's point, which I understood to be a point of principle as to the operation of the agreement, whether it wouldn't have been possible to recommence supplies if the appellant chose to do that. In other words, chose to stop invoking the
seems to be the case
relief provision.
I'm sorry, it seems to be the case that that was not a possibility which occurred to the respondent, because we've seen what Mr. Abraham thought about it, and indeed what the judge in the Court of Appeal thought about it, was that the clause simply gave us an opportunity for an out should we wish to avail ourselves of it.
Yes, thank you.
Because I think on the question of damages, which is where I was, I think I have made the principal submissions about that. We say that, bearing in mind that, well, I think I've said that because the
yes, Lord Leggett.
Yeah.
Liquidated damages. On the liquidated damages point, if you've made your submissions, what is your answer, if any, to the objection that in relation to the 3 days which you say were covered by the grace period, you failed to give the relevant notice under subclause 8, and therefore you can't avail yourself of the grace period for those 3 days?
Well, my lord, I think I have to accept that I'm in difficulties on that, and indeed I did indicate that that was something which we would have to face. Insofar as the other 2 periods are concerned, we say that they were wrongly withheld, but we didn't. I suppose in the circumstances, there was no evidence put forward of, well, to satisfy the point that your lordship's just made. My lords, the position then would be that we should succeed in relation to the 2 periods that I've identified, the 29th and the 31st of May, and the 8th and 12th of June, and the damages that were awarded and confirmed by the Court of Appeal in relation to those dates should be deducted from the total damages award which was made by the Court of Appeal, which was $385,000. My lords, if the board is with us on the waiver issues, the appellant's counterclaim should succeed. This is summarized in our written case at paragraph 81, which is on page 1102, because the respondent's refusal to permit reliance on clause 10 was a breach of contract by virtue of its failure to grant the requested performance relief. And the measure of damages would be, my lord, yes.
I'm puzzled by your argument on this. I can't understand where you derive the obligation of which there was a breach. Surely if you had a right not to perform, you simply had that. You were entitled not to perform.
Well,
because it doesn't give you a claim for damages. What forced you to perform, in fact, was the court's order.
Well, that's
correct. If anything, you'd be relying on an undertaking in damages if there was one.
Well, there was not an undertaking in damages, but surely the court's order was based upon the refusal to the breach of contract by the.
It wasn't. It was based on the that you had the right, which you say you did. That doesn't mean the other side was in breach of an obligation.
Well, my lords, the clause 10 permitted us to request performance relief, and it was our request which was refused by the Electricity Corporation. Now, that is a breach of contract because we.
You say it works that if you make a request, which you're entitled to make, that they refuse it, you're still forced to perform. You say you still have a contractual obligation to perform if your request isn't accepted.
Well, that. I may need to go back to clause 10, but my understanding of the position is that the right was under the contract, and it is denied under the contract, then that is a breach of the contract by the Yes.
On the
Or
face of it,
put
it
it
doesn't require
another
you
way,
to
the
carry
breach-
on. If
the
you
breach
have the
is-
rights not to perform, you just don't perform.
No, but the breach is surely to insist on performance.
Well, then you say if that happens, you're obliged to perform, even though you were entitled to claim performance relief. Is that how you construe the contract?
Well, surely the parties each had their respective rights under the contract. The defendant, I'm sorry, the respondent now, the electricity company, it insisted on its right to deny our right. I would have suggested that that was a breach of the contract, which would entitle us to damages. It is correct that the court ordered us to continue, and indeed, for what it's worth, your lordships may be interested to know that we did continue until the end of the 4-year term at a loss. So the contract was performed by us up until the 31st of August 2018.
Well, you might do better, might you? Instead of saying there was an obligation to grant your request for performance release, simply to say that you had an obligation to perform the contract by delivering, unless your request was accepted. Maybe that's a more rational way of putting it.
Well, Lord, I'm grateful for, any assistance, but I don't think the point has ever been taken against us that if we are right and they're wrong, we are not entitled to recover under our counterclaim.
No, that's why I'm taking it now, Mr. Guthrie.
Well, yeah.
Mr. Guthrie, I had understood, perhaps naively, that the argument behind your paragraph 81 was that there had been a repudiatory breach by the respondent by its indicating that it simply refused to accept the contract should be performed in accordance with its terms. Yeah. Which, if you were right on the waiver argument, they had indicated that they were not going to act in accordance with the contract and treat it as being alive and so on. Is that a wrong way of looking at it?
No, my lord, it's not. And although long experience has taught me to be wary of invitations from the board to agree, I think I do agree with that. And so that would entitle us to damages. And the measure of damage is the amount of loss that we have incurred by being forced to continue to deliver. And that is a matter which, of course, I can't ask your lordships to calculate yourselves, but it would be.
Can I ask, does it matter which way round one analyses it? Because, as you say, you did continue to perform in circumstances where you say you weren't obliged to perform. So actually, is there a different measure of damages depending on whether one analyses it as a repudiation of the agreement or simply the agreement remains on foot, but you're being made to perform in circumstances where there's no obligation to perform?
I don't think there would be a different measure of damages.
Voluntarily perform.
I'm sorry?
I'm not sure how you can get damages at all if you just choose to perform, unless they were in breach of some obligation. Well, breach of contract.
I don't think I've necessarily understood my Lord Searle's query then. I thought he was proceeding on the basis that there was a repudiatory breach of contract.
Well, my latter question was to ask whether it mattered whether there was a repudiation or not. If there was a repudiation, you, I assume, would get damages reflecting the fact that the contract was repudiated, but you have suffered a loss resulting from that.
Well, that is the way in which I would choose to put it, yes. So we are entitled to loss damages on that basis.
My latter question was directed to whether there is an alternative analysis that even if there hadn't been a repudiation and acceptance, so that the contract remained on foot, but you go on supplying in circumstance and taking payment at a rate which you are unhappy with for the remaining period of the contract, where you say the obligation to extract that money from you should not have been treated as having arisen. Does that give rise to effectively the same quantum of damages if one analyses it in that way?
I think we need to think about it, my lords. I'm sorry to say that, but it is towards the end of my submissions. I'm a little.
Definitely. I was asking for assistance, not to try to pin you down.
Yeah.
Thank you.
Yes, Lord Hamlin.
Just Mr. Guthrie, on the question of repudiatory breach, if they were in repudiation, did you purport to accept that at any stage?
Yes, because
Where's that?
well, we were attempting to insist on supplying the fuel at the increased price, which we said we were entitled to do. I'm just
Would you like to return to this in your reply, Mr. Guthrie?
I think I would, my lord. I'm sorry, it's a little difficult because one of the things I can't do very easily is confer with my junior, who's
That's all right. That's all right.
meters away.
And we will put that off until you make your reply.
My lord,
Anything else you want to say now?
well, I think the only other thing I was going to say was that if your lordships are with us, it would not, I think, be possible for us to ask for any particular calculations to be done by your lordships.
No.
And we would submit that the approach should, or the course should be taken of remitting the matter to the Supreme Court. I think I've already told your lordships that in fact the contract was on foot until or the deliveries continued to be made according to the courts until the very end of the day.
The contract period, yeah.
No, my lords, I think for the moment, reserving my position, if I may, to my reply.
Yes, of course. Does Ms. Patel wish to follow?
No, she doesn't, my lord. It's a little difficult too, because I don't know if your lordships are aware of this, but the rules seem to prevent more than one of us being active speakers. So she would have to come and sit where I sit, but no, she doesn't, my lord.
I see. Well, thank you very much. We are trying to do something about that, but these things are in a state of evolution, shall we say. Thank you very much indeed, Mr. Guthrie. Now, Mr. Dennis.
My lords.
Yes.
Might I begin, my lord, simply by observing that the first submission made by my learned friend is not one which I believe can be sustained in the context of the evidence, which was before the learned trial judge, and in relation to the applicable law. My learned friend submitted that what was before the learned trial judge was not a matter which could be resolved on the basis of an issue of fact. And it was being suggested that the trial judge erred in approaching it in this way. However, my lords, it is difficult to see how it could have been approached in any other way than the way in which the learned trial judge actually approached it. Because what we had here were two competing different positions. The appellant was saying that as at the date which they purported to, they had a right to terminate the contract, suspend deliveries indefinitely as a result of the Hovensa closure. Whereas the respondent's position was that by the time they purported to do that, they had lost that right. Why? Because they had made an election which was communicated to the respondent that they were not going to terminate the contract, but rather would continue to perform on the basis of an identification of an alternative source of supply and base from which to fulfill their contractual obligations. The learned trial judge therefore had to decide, as a matter of fact, on the evidence before her, whether or not the conduct of the appellant was such that the conclusion could be arrived at that they did, in fact, make such an election, which would then preclude their later attempt to rely on that event as a basis for terminating the agreement. So this was clearly a matter which had that at the heart of the contest between the parties. And so, my lords, it is our submission that the learned trial judge cannot reasonably be criticized for having dealt with the matter in this way. And that is precisely why the learned trial judge took the approach where she examined the relevant correspondence, she examined the oral evidence which was given by the parties at trial, and of course the relevant witness statements, and arrived at a conclusion that based upon that material before her, she found that there was indeed an election. That approach, my lords, we submit was unexceptionable, and there is really no sustainable basis for criticizing the learned trial judge on that score. Having said that, my lords, in dealing with the purported attempt by the appellant to terminate the contract on the date that it did, and the respondent's assertion that by that time, that was not an option open to it, one has to bear carefully in mind the context of the agreement and the context of clause 10. It is common ground, my lords, that this contract was negotiated in a climate where there were very few options. There was a paucity of avenues for the supply of fuel to the respondent, who was charged with the responsibility of providing electricity to the territory. It is not as if they could easily source alternative sources of supply. And that is why it was extremely critical that the source which it ultimately procured and made contractual arrangements to pursue were definite and certain. That is the context in which clause 10.3 was introduced into the agreement because, again, it is common ground that both sides were aware and had at the top of their minds the fact that the source of supply in relation to this particular contract, namely the Hovensa St. Croix facility, was itself, I suppose one could say, a tenuous one, because they acknowledged that there was a possibility that Hovensa would close, and that in those circumstances, the appellant would, in all probability then, not be able to fulfill their obligations under this very important fuel supply agreement. And that is why clause 10.3 makes provision specifically for that event. And what clause 10.3 does is to give the appellant, in the event of that contingency materializing, certain options. And what it does is to allow the appellant in those circumstances to reduce supply. In fact, it could do a range of things. It could reduce supply, it could temporarily suspend supply. But at the top end of the rights which that eventuality would allow it was the right to terminate. And they were specifically given that right to terminate clearly because both parties contemplated that that might have become necessary if in fact this facility closed and it was no longer able to supply under that contract. In that context,
sorry to interrupt.
Yes, Lord Leggett.
You say it clearly gave a right to terminate the contract, but there's nothing in clause 10 that I can find that gives any right to terminate the contract. It simply gives a right to withhold, reduce or suspend deliveries, which is not the same thing.
Well, my lord, if we could just look at the agreement at clause 10, and having regard to the wording of it, which is found at page
889. Yeah.
889, my lords. And particularly at page 890, if by reason of any of the causes referred to in the previous paragraphs, including the closure of Hovensa, either the availability from the seller's or supplier's sources of supply, crude oil or refined petroleum products, or the seller's lease storage facilities to St. Croix, whether deliverable under this agreement or not, or the normal means of transport of such crude oil products is delayed, hindered, interfered with, curtailed, or prevented, then the seller shall be at liberty, and this is the important portion of it, to withhold, reduce, or suspend the deliveries hereunder, to such extent as the seller, and here is the gravamen of the matter, may in its absolute discretion think fit, and the seller shall not be bound to purchase or otherwise make good shortages resulting from such cases. So not only was it in those circumstances at liberty to withhold supply, but it could do so in its absolute discretion to the extent that it thinks fit. Now that would include anything from reducing the volume of supply to suspending supply completely. A complete suspension of supply would, in those circumstances, obviously and inexorably constitute a termination of the agreement to supply. Because if it is given the power to suspend supply to the extent that it thought fit in its absolute discretion, if it is given the power to withhold supply to the extent that it thought fit in its absolute discretion, and having regard to the context in which the agreement was arrived at, the inexorable interpretation of this contract is that in substance, it did, in the event of that contingency arising, give the appellant the right to terminate the contract, because a suspension of supplies in the absolute discretion of the appellant, to any extent that it thinks fit, must include the right to withhold completely, indefinitely, permanently. And my lords, I do not believe that it has ever been disputed, or that it was ever in contention, that this clause, in fact, gave the appellant the right to terminate. The appellant's position in the court below, in the Court of Appeal, and up to this point has always been, yes, we do have the right to terminate, but we were not obliged to exercise or to avail ourselves of that right at the time when we were given notice of the closure of the Hovensa facility.
Well, I'm just wondering about that, Mr. Dennis. The right exercisable under clause 10.2 is conditional upon the conditions setting that are set out in clause 10.1 continuing to obtain. Is that not right?
Could you repeat that, my lords? I didn't quite get that.
Yes, I'm saying in order to avail of the right given to the appellant by clause 10.2, is it not correct that the circumstances outlined in clause 10.1 must continue to obtain?
Yes, my lords, that clause refers back to the eventualities set out in subclause 1, which included at subclause D the very eventuality which is the subject of this case, namely the closure of Hovensa, because clause 10D does speak to any curtailment, failure, or cessation of supplies of crude oil or refined petroleum products from any of the seller or its supplier's source of supply, or seller's lease storage facilities on St. Croix, USVI, which are in fact sources of supply. So the contract acknowledged that Hovensa was in fact a source of supply. And if that supply...
Quite so. What would have happened in a theoretical situation, not related to the circumstances of this case, but let us suppose Hovensa resumed supply. The appellant would have been under an obligation to resume the supply to your client, would it not?
Well, my lords, the contract did give the respondent the option, in the event that the appellant was unable to fulfill its obligations of supply under the contract, to seek alternative sources of supply.
Well, quite, but that doesn't meet the point. That doesn't meet the point that I'm trying to put here. It's a development of Lord Leggett's point. I mean, does the contract, does clause 10 in fact invest the appellant with the right to terminate? The suspension of the performance of its obligations is conditional upon the circumstances in 10.1.
Yes, ma'am.
To be at odds with the assertion that clause 10 in effect gave the appellant the right to terminate.
It is not at odds, I would submit, my lords, because all that clause, all that the conjoint effect of clause 10.1 and 2 does is to provide a mechanism in the event of any of these contingencies, such as the Hovensa closure arising. It puts the appellant in a position where it would be able to avoid liability for a failure to supply, a failure based on the fact that its own source of supply is no longer available to it. And if its source of supply is no longer available to it, by virtue of which it cannot perform, then in those circumstances, it would be entitled to say to the respondent, look, our source of supply has dried up. We can no longer perform our obligations under the contract. Now, if it can no longer perform its obligations under the contract, it would, in reality, even if not in theory, bring the contract to an end effectively. And the appellant would then have to seek an alternative source of supply. Again, my lords, bearing in mind that if one looks at it on the theoretical basis, that theoretically the appellant could come at some later stage and say, our source of supply is now once again available to us. We would like to resume supplying. In a theoretical context, that may be possible. But your lordships have to bear in mind that in reality, the corporation was dependent upon a reliable source of supply. And so if the appellant came and said, we can no longer perform because our source of supply has dried up or is no longer available to us, the corporation would, in those circumstances, have no choice but to move on, to accept that as a termination of the obligations of the appellant under the contract and move on to find an alternative source of supply, bearing in mind that it would not have been possible in a practical world, given its obligation, for it simply to sit and wait for the appellant until such time as it was able to source some alternative means of supply.
Wouldn't, excuse me, Mr. Neal, wouldn't the way to analyze that be to say that if appellant makes it clear that it's relying on its right to claim performance relief and won't be providing supplies for a long time or at all, then the respondent has the right to terminate the contract.
Right. Yes.
Because a failure to perform or an indication that you don't intend to perform, even if it's excusable, can still justify termination of the contract. There are cases, plenty of cases which show that. If it means the contract is, if it goes to the route of performance or so forth.
Even though, my lords, the respondent might have in those circumstances, and bearing in mind, this is not what actually happened in this case, but in a hypothetical case, if the appellant had approached the respondent to say, we can no longer perform, then in those circumstances, it may well be that the respondent could itself terminate the contract. But that is not what happened here. That is not the factual scenario which we have here.
He was suggesting that that's what happened here, but this is all directed to your, this is all directed to your claim that the appellant was entitled to terminate the contract.
The appellant, my lords, not the respondent. Yes. So, and the point I was going on to make from that is that even though in a theoretical setting, the respondent might have been, in those circumstances, be able to say, well, since you're no longer able to perform and you've told us that, we are going to terminate the contract. That would not mean that the appellant's own right to permanently suspend delivery pursuant to clause 10.3, which would be an effective termination of the contract. That does not mean that the appellant itself would not also have the right, once it became aware of the fact that it was no longer able to fulfill its obligations because of this eventuality, it would still be open to it, regardless of what the respondent could do, to itself terminate the contract by permanently withholding supply. It had that right under clause 10.3, having regard to the context in which the contract was negotiated, the background, and the importance of there being certainty as far as the respondent was concerned about its source of supply of fuel.
Yes. Well, perhaps we can move on.
Thank you, Madam. My learned friend criticized the learned trial judge on the footing that the judge saw the contract as requiring the defendant to make up its mind to terminate or not to terminate. This, we say, my lads, is an unfair criticism of the learned trial judge. Because again, what we had here is a situation in which the source of supply, which was clearly identified in the contract, was clearly no longer going to be a source of supply. In those circumstances, the appellant had certain rights under clause 10.3. We have already looked at clause 10.3 and seen that among the things it would have been entitled to do in these circumstances would be to withhold supply, reduce supplies, or suspend supplies to such extent as it saw fit in its absolute discretion. Now, since that right included everything from a temporary suspension on the one hand to a complete and permanent withholding of supply on the other, the latter of which would in effect bring the contract to an end, it is clear that the appellant, once that eventuality arose, had the right, in that sense, to terminate the agreement. And that is where the doctrine of waiver arose. Because once that eventuality came about, the appellant was undeniably faced with a choice. Do we exercise our right under the contract, clause 10.3, to permanently withhold supplies, which would be tantamount to a termination of the agreement and of its obligations under it? Or do we continue to perform our obligations to supply? And one of the ways in which it could have continued the contract, notwithstanding its right to terminate, by continuing to supply, would be, if it could, to find some alternative source of supply to Hovensa, which would then allow it to continue to perform. On the respondent's case, that is precisely the course, the latter course, is the course which the appellant chose. It did not, faced with the notice of closure, say to the respondent, in light of this, in light of the non-availability of our Hovensa supply, which is the designated source of supply under the contract, we are no longer able to supply, and therefore we are invoking our right under clause 10.3 to permanently suspend deliveries and supplies to you. It did not do that. Instead of doing that, it sought, on our case, an alternative source of supply from Antigua, from which base it continued to fulfill its obligations under the contract. Now, in a context where the respondent's case was that, given those circumstances, the appellant had made a clear election, which was communicated through its conduct and through correspondence to the appellant. Was there, in law and in fact, such an election which was communicated? And if so, what would be the consequence of that? And that is the way in which we say the trial judge correctly analyzed analyzed the case, analyzed the evidence. And that is the analysis which the Court of Appeal refused to interfere with, and which we say was correct also on the part of the Court of Appeal. It is important, therefore, my lords, because when one is looking at waiver by election, and I will just pause here to make the point that my learned friend in his submissions, and to some extent in his oral submissions before your lordship, seem to be importing an analysis relevant to waiver by estoppel into the case. But it is important to bear in mind that waiver by estoppel was never an issue either before the learned trial judge or before the Court of Appeal. It was not the respondent's case that waiver by estoppel arose. It was always the respondent's case that what was the live issue here as a matter of law and fact was waiver by election, which, as the authority shows, and which, as my learned friend accepts, is a clearly different analysis. And so I believe, my lords, we can put to one side any arguments or any analysis based on waiver by estoppel. It simply is not an issue which arises in this case. And both the learned trial judge and the Court of Appeal were clearly right in not going down that path.
Can I just interrupt for a moment, Mr. Dennis? If you would look again at 10.2d, any curtailment, failure, or cessation of supplies of crude oil from any of the seller or its suppliers, a source of supply. Let us suppose in this case Delta had said to your client, well, we no longer get our supply from Delta, and therefore we're going to exercise our right under 10.3 to suspend supplies to you until further notice. But we will seek an alternative source, and depending on the amount charged by that alternative source, we may come to you to ask for an increased payment. Would that amount to a termination?
That would not amount to a termination, my lord, if indeed it said we are going to source an alternative source from which we will continue to perform our obligations, subject to there being acceptable price arrangements and so on in place. In those circumstances, I do not believe it could then be said to be terminating the agreement, because it would be putting itself in a position, it would have been taking steps to put itself in a position to continue to perform. So there would have been no termination there. Now, if Delta had indeed said to the respondent, this is what we are going to do. We are going to continue performing in the meantime while we look at these alternative sources to be able to continue to meet our supply obligations into the future. If that is what they in fact did, then there would be some reality or some truth or credence to the notion that that supply in those circumstances was nothing more than a temporary supply. But again, that hypothetical scenario is not in fact what happened in this case, because at no stage did the appellant say to the respondent, in view of the closure of events which has made our continuing supply to you from that source possible so that we can fulfill our obligations under the contract. And no time did it say, having regard to that, we are going to source an alternate temporary base of supply and will continue to supply you contingent upon our being able to have satisfactory pricing arrangements in place. They did not do that. They are asserting in their case that that is what they did, but the evidence does not bear that out. And their assertion that this was at all times merely a temporary source of supply, and that the respondents had at all material times been made aware of that, was rejected categorically by the learned trial judge. She did not accept their evidence that this was merely temporary and that the temporary nature of that supply, pending discussions between the parties about pricing and other issues, was in fact what happened. She did not accept as a matter of fact, but accepted rather that they chose to continue to perform, said nothing about this being a temporary source of supply. To the contrary, advising the respondent that they had that they were fulfilling their obligations from our new port of supply, from our new base of supply, thereby continuing to meet their obligations from this new source. So again, my lords, to encapsulate my response to your lordship, as a hypothetical, yes, but that hypothetical which your lordship posed simply does not represent the factual scenario which actually obtained in this case. Perhaps then, my lords, this would be a good time to make good our point set out in detail in our case, that the learned trial judge had before her ample evidence on which she could have arrived at the conclusion, as a matter of a factual finding, that the appellant had made an election and communicated it. And the Court of Appeal's endorsement of that position to say that her ladyship had ample evidence before her on the basis of which she could have arrived at that finding. And perhaps, my lord, the best place to begin would be the letter of the 27th of January 2015, which your lordships may turn up at page 933 of the record. '27th of January 2015. I'm sorry, my lords, I seem to have had the reference to that page incorrect.
Well, 933 is a letter of the 27th of January.
Yes. I'm sorry, my lords, I made an error there. I was looking at 993 of my bundle rather than 933, which I meant to. So this is the letter of the 27th of January.
At 993, it's a letter of the, I'm sorry, Mr. Dennis, but the letter on page 993 is dated the 30th of May, 2015.
Yes, my lord, that was an error on my part, my lords. I meant to turn up page 933.
Yes, well, I think that you referred us to in the first place.
Yes, my lords. That is
you'd like us to look at the one at 933. Is that right?
Correct, my lords.
Yes, right. Thank you. Yes.
And in this letter, my lords, this is the letter in which the respondent seeks performance relief having regard to the Hovensa closure. And if your lordship looks at the middle of that further, please note that notice that was given from Hovensa for us to move by the end of January 2015 made it difficult for us to empty the tanks within that specified period. This has caused in us being able to return to supply product to BVI in a timely manner. So as at this point, by this point, they had obtained the notice of termination of the Hovensa facilities from the 1st of December of 2014. And here they are seeking performance relief in relation to the difficulties associated with that eventuality. Then the letter of January 28. This was the letter in which the appellant sent the actual notice of the Hovensa closure, which they had received in December of 2014. They sent the notice to the respondent on the cover of this letter. And in that they asked for a meeting to discuss the current contract implications. And the letter reads, this correspondence is for the purpose again of notifying you. And this, my lords, is at page 935 of the record, the letter of January 28.
Yes.
I'm sorry, my lords. That's a letter from the corporation. The next letter to take your lordships to is at page 936.
Yes.
936. Please be advised that the attached letter is for your immediate attention. You will note that our current contract stipulates storage in Hovensa. With this being the case, we would like to schedule a meeting with you to discuss our current contract and implications thereof relating to the closing of Hovensa. Now, my lords, that I pause here to note that the appellant in its case suggests that this letter was a clear indication to the respondent that it was seeking a variation of the existing contract by reason of the Hovensa closure. However, I would ask your lordships to note that there is nothing in this letter which so suggests. It simply says, we would like to schedule a meeting with you to discuss our current contract and implications thereof. It doesn't say anything about wishing to seek a variation. In fact, none of the subsequent correspondence speaks about variation of the terms of the contract until well after we say they had made an election where they spoke about concessions which they may be able to, which they might have been prepared to introduce when they discovered that performing the contract from their new source of supply was in fact proving to be unprofitable for them. Then, my lords, the letter of the 2nd of February 2015, which is at page 937, is the next letter.
Yes.
In this letter, the appellant states that it was in the transition phase to Antigua. And the third paragraph, you would recall that I communicated to you via correspondence dated 27th January as it relates to the closing of Hovensa St. Croix. We are now in the transition phase to Antigua for lifting of the product. Documentation will be sent to you in usual manner in accordance with this contract. So here, and in the next paragraph, this under inventory is caused for this very reason, as we are now loading in Antigua today to be back in the BVI market on Tuesday, 3rd February. This performance relief is in relation to the closing of Ventus in Croy and the transition to a new loading port in Antigua. Thank you for your kind understanding. So, having received the notice of the closure in December, having notified the respondent of it in January, up until this point, it takes no step to exercise what we say was its right under 10.3 to suspend deliveries completely, thereby terminating the contract. It does not do that. It seeks performance relief as a result of that closure and delays associated with it. But in this letter of February 2nd, it is advising the respondent of its transition to a new facility of supply. In other words, Hovensa is now closed to them. And in this letter, they are clearly indicating that they are continuing to perform their obligations under the contract from a new source of supply. And this, my lords,
If this represents evidence of election, why is there any reference to performance relief? What's the point of them invoking performance relief?
My lord, because they are entitled to performance relief in the event of any delays in supply. And so, my lords, in order for them to avoid having to pay liquidated damages, it would have been incumbent upon them to explain why there was a delay in the supply. And in these circumstances, because they were transitioning from Hovensa to their new port and base of supply, they encountered delays. And so the clause in the contract which allowed them performance relief was open to them to avail themselves of. And that is all that they are doing now. So it made perfect sense, my lord, for them to be seeking performance relief against that background. Because as they have indicated in the final paragraph of their letter, this under inventory, they make it clear, is caused for this reason. That is for the Hovensa closure.
Yes, but your submission, as I understand it, that this represents an intention on the part of Delta to continue to discharge its obligations under the contract. And all that I'm pointing out is that seems slightly incongruous in a letter which claims performance relief from the obligations in the contract.
No, my lord, one has to separate two things. On the one hand, performance relief could have been requested in different forms. At the most drastic end of the spectrum, they could have claimed permanent performance relief. That is why clause 10.3 says they may suspend or withhold supplies in their absolute discretion to the extent that they saw fit. Now, if they were suspending supply permanently, then what they would in those circumstances be entitled to do was to claim performance relief on the basis that we are no longer able to supply. We are therefore permanently suspending the supply. And therefore, in order for you not to hold us liable for damages for our failure to supply, we are exercising our right under 10.3 to claim performance relief for permanently withholding and therefore not being able to supply. So that is one scenario in which they could have asked for performance relief. And the contract allows them to claim performance relief in this eventuality. But in this case, that is not what was happening. What was happening was that rather than permanently suspending supply, what they were doing was transitioning to their new port in Antigua, which means in order to continue to fulfill their obligations to supply. But while they were so transitioning, my Lord, I have lost you.
Sorry. I think what underlies my Lord's question to you was this. Here, there, as I think you accept, there are a range of options open to Delta. Stopping supply altogether, stopping temporarily, moving to another port, continuing without any delay or interruption. For there to be an election, you have to have a choice between two alternative and inconsistent options. And you simply don't have that if what you have is in fact a choice among a whole range of alternatives. It isn't a stark dilemma that engages election at all.
Well, my Lord, I would answer in this way. When one looks at the range of options, delay, suspension at one end and termination at the one end, anything short of termination, anything short of permanent suspension of supply would constitute an affirmation of the contract and an ongoing performance of it. So of the range of options which were there, withholding supply temporarily, suspending supply, reducing the volume of supply, any one of those, had it chosen to do that, would have constituted an affirmation of the contract, because it meant that by choosing those lesser options to permanent withholding of supply, ergo termination, would have meant it was continuing to perform.
All right, suppose instead of later on, suppose they ruled out termination because they elected to keep it going, could they later on have said, well, now what we'd like to do is suspend supply for all the rest of the contract except for a couple of days at the end. We're not going to terminate it, but we're just upping the level within the range now. Was that still open to them? Because they didn't terminate the contract, but they were entitled to use other options within the range. So now they say, well, we're just, we say, all right, well, now we're not going to supply until very near the end of the contract. We're not terminating it altogether. Is that still open to them?
I'm not sure I'm following your lordship's question. Could you?
Sorry, I may not have put it clearly. Suppose they had to choose to terminate the contract or keep it going, and they choose to keep the contract going. but they still have the range of options that you accept are open to them. Could they later on exercise an option of saying, we now wish to suspend supply for 2 years, let's say? We're not terminating the contract altogether. We've elected not to do that. But we do consider now that we should suspend for 2 years. Is that still open in June?
Well, my lord, to the extent that any of the eventualities outlined in clause 10.1 arose, once any of those eventualities in clause 10.1 arose, the respondent would be entitled to rely on clause 10.3 to exercise any of the rights which it conferred. So if that meant suspending supplies, for example, hypothetically, if having moved to its new source of supply in Antigua, it encountered difficulties with that source, which meant that it could no longer fulfill its obligations as contemplated, then indeed, in that scenario, it would have been entitled to suspend supply. It would have been
exactly what happened. It found it was more expensive. It found it was more expensive than it anticipated. It's exactly what happened, isn't it?
Well, I'm sorry, my lord.
Isn't that exactly what happened? When it moved to Antigua, it found it was more expensive, and so it chose to suspend supply for the rest of the contract period.
Well, my lords, the fact that it found that it was more expensive to supply was not an eventuality provided for by clause 1, which would give them a right to terminate or to suspend. There is nothing in the contract which gives them the right to suspend performed supplies, to reduce supplies, to withhold supplies, simply because from a commercial standpoint, it was no longer profitable for them to continue to supply. That is simply not an option which would have been open to them. The only basis upon which, having identified a new source of supply, it could properly withhold or suspend supplies and rely upon clause 10.1 is in circumstances where clause 10.3 is in circumstances where one of the eventualities in clause 10.1 applies. And the fact that it became more expensive for them to continue to fulfill their obligations is simply not an eventuality provided for in the contract. And that is why, my lords, the appellants themselves candidly admitted in their evidence before the learned trial judge that they sought to negotiate a price increase outside the terms of the contract. Why outside the terms of the contract? Because they recognized that they had no right to renegotiate price within the existing terms and framework of the contract. So, my lords, whilst in theory, the appellant could seek to terminate or to suspend supplies because of commercial hardship, it was simply not an eventuality which clause 10.1 provided to allow them to do so.
Yes, Mr. Dennis.
Yes. So, my lords, I would just pick up my look at the correspondence. Now, my lords, it is not for a moment being suggested that the last letter which I took your lordships to.
May I ask a question?
Yes, yes, indeed.
Mr. Dennis, just before we leave clause 10 at the moment, clause 10.3 makes the obtaining of performance relief conditional upon the non-performing party, that's Delta, being able to prove that it took reasonable steps to minimize delay or damage caused by foreseeable events. Would a request by Delta facing the loss of its primary source of supply and the inevitability of only being able to continue supply at that level at a greater cost and at a loss, would it have been within reasonable steps for Delta to say, well, anticipating that problem, we'd like to discuss with you a price increase?
Well, my lords, it may have been to them to ask the respondent to discuss a price increase. But my lord, that would be outside the terms of the contract. And in fact, as matters actually transpired, that is what they sought to do. Because that is what they sought to do. They sought, after taking steps to identify a new source of supply, after taking steps to identify a new port so as to be able to continue to fulfill their obligations under the contract. And after having done so, and it becoming apparent to them that this was going to lead to commercial hardship, they then sought to negotiate a price increase, which the respondent refused to entertain. But that ability for them to seek to negotiate or renegotiate price does not in any way alter or impact the fact that by that time they had already made an election to continue supply from that source. And if the respondent were prepared to entertain a price increase, yes, they might have arrived at some new arrangements, which could then be memorialized as part of the agreement. But as things then stood, an election had either been made or it had not been made. Once that election was made, it was bound by it, regardless of whether or not it could then seek to minimize the impact of its commercial difficulties by trying to get some measure of accommodation from the respondent through negotiations. So the one does not affect the other.
Well, let's just suppose that in mid-January, Delta had said to your client, we're losing our primary supplier, and in 3 weeks' time, when we have to stop taking supply from there, we're simply going to stop supplying you at all. And let's suppose that that would cause catastrophic damage to your client in terms of reputational loss, the inability to provide power, and so on and so forth. And it did that. You say that it had to choose. It was an all or nothing choice to be made at that stage by the end of January. Would not your client have been able to say, but hold on, you didn't take reasonable steps to minimize that catastrophic damage, which not giving us anything would cause us, if you come along and asked us to make a very small increase in the price, we would have agreed and we would have hardly suffered any loss at all. What's underlying my question is the proposition that if you read clause 10 with proper and due regard to 10.3, it contemplates not that a party facing a supply failure will just throw its hands in the air and say, right, we're off, we're not doing any more, we're walking away, but it will do what it can to come up with some means of continuing the supply. And obviously, what's behind my question is, isn't that what Delta did?
And my answer to that, my lords, is no. And my answer to that is no, because its attempt to negotiate a price increase did not come at the front end of the factual matrix. Your lordship's hypothetical proposition is that upon receiving the notice, the appellant approached the corporation to say, we've lost our source of supply. We want to continue to supply to minimize damage, and therefore, and we can only do so if we get a price increase. So let's talk about that. If that is what they had done, then we would not be here today. But my lord, that hypothetical again is not what happened here.
Yes, Lord Sayers.
Yes, Mr. Chair, I thought on the facts, it was the letter of, I think it's the 28th of January, where the appellant was asking for a meeting to discuss ways forward in view of the Havensa closure. And I also did understand, although there is some dispute about what exactly was said at the meeting on the 6th of February, that that was a meeting which was held to discuss ways forward, including possible price increases. And all that is happening before the time when the judge finds that there was an election made. Can you help us with that?
Well, my lords, I will answer that by saying the learned trial judge, in fact, categorically rejected, having considered the evidence before her, she categorically rejected the appellant's version of events, that there was any discussion in relation to the suggestion that supplies were going to be temporary and that they were contingent, they would be contingent upon a price increase. She categorically rejects that at paragraph 83 of her judgment. And so, my lords, there is no room for an argument to be made that on the facts, Delta, the appellant, at any stage prior to when the judge found that they had made an election, they had sought to engage the respondent on the issue of a price increase in order to minimize the potential loss to the corporation of the source of supply if they were not in a position to continue to supply at an economic level. So that the factual matrix which we have and which the trial judge accepted and which the Court of Appeal refused to interfere with was that there was no such discussion at which Delta at any stage said to the corporation before they had made their election, we can continue to supply to minimize the fallout of all of this, by negotiating a price increase. It is just not a part of the factual matrix. The trial judge looked at the evidence and did not accept that as a matter of fact. And I could take your lordship to paragraph 83.
I think Lord Sales may have had another question.
Well, I was only going to say thank you for the assistance, but if you want to take us to paragraph 83, that would be helpful as well.
Yes, my lords.
Except that now we've gone beyond our scheduled time. Perhaps you could take us to paragraph 83 tomorrow morning, or rather
Yes,
tomorrow afternoon.
And Lord Sales, if it is that there's any doubt about whether I addressed your specific question, my lord, I'd be happy to revisit that to make sure that I do indeed address that point. We
can all reflect on that overnight, and we can return to it tomorrow afternoon. Thank you very much indeed. The court is adjourned in the meantime until tomorrow at 1 o'clock. Thank you very much.